Good evening. Welcome to a special June meeting of the Niskayuna Zoning Board of Appeals. Before we get started, Mr. Kenny, will you call the roll, please?
Mr. Lataif?
Here.
Mr. Dolman?
Here.
Ms. Pacheco?
Here.
Mr. Daly?
Here.
Mr. Trimarchi?
Here.
Mr. Antonikowski?
Here.
Chairperson Hoke?
Here. Tonight, we have a unique matter, a relatively unique matter from this board's perspective. Typically, we are assessing requests for variances. That's not the purpose of tonight's meeting. Tonight's meeting, this board is being called to analyze and interpret a code section, and code section of the Niskayuna zoning code. There's been an appeal made by Jeffrey Palumbo alleging that the planning board misinterpreted the Niskayuna zoning code with respect to a convenience store being located at 2339 Troy Schenectady Road. The appellant in this matter is asserting that a convenience store is a pre-existing non-conforming use at the site. So we are going to sit here, the zoning board is going to sit here and look at this afresh, meaning we're not bound by the planning board's determination. And we're going to
Chairperson Hope, I'm sorry to interject, but it wasn't actually the planning board. It's the planning department.
planning department, I apologize, and assess the facts and the code and apply the section as we see it. So the way this process is going to move forward tonight, we're going to call the appellant to present their case to this board as to why they believe that a convenience store is a pre-existing non-conforming use, or it should be allowed at the location. And then the town is going to present their case as to why the initial determination was correct. I would like to just point out that this evening, because it's unique, we're not going to have public comment relative to this application or this appeal. There may be a point in the future when this matter is back before the zoning board. And at that point, certainly public comment would be invited. So I just wanted to let everybody know that if you're here to have public comment, I don't want you to wait for a long time to be disappointed. So, but obviously everybody's welcome to stay, and we appreciate your attendance this evening. So with that being said, if we can have the appellant come forward. What's that? Oh, I'm sorry. I'm jumping ahead of myself. We have to read the matter for this evening. Mr. Kenny, we read the matter on the agenda?
Appeal by Jeffrey Palumbo, agent, to appeal the January 28th, 2025 interpretation from the planning department that a use variance is required for the proposed expansion of the pre-existing non-conforming business at 2349/2339 Troy Schenectady Road, Niskayuna, New York, located in the R1 low-density residential zoning district.
Mr. Palumbo?
Thank you. I'm Jeff Palumbo with the law firm of Block Longo, representing the petitioner here this evening.
Palumbo, can you just give an address, business address?
Sure, 9276 Main Street in the town of Clarence. We also have Rochester and Syracuse offices, but I'm mostly out of the Clarence office. So the first question, I guess, is the issue of the public comment. I thought that this was a public hearing, but if there's some reason why it's not scheduled as a public hearing, is there a reason for that?
Well, I've been advised that since this board is sitting in a quasi judicial function here, that we want to have the record clear and interpret what you're saying and the town is saying to render an opinion. You're certainly free to call anybody to come forward to support your position. If there's people that want to be sworn and offer testimony this evening, we would allow that. But as far as a general public comment interpreting the code section, we don't want to have that supplanted or supplant the judgment of the board. That's the legal opinion that I've been offered. And Ms. Finian, if I'm incorrect on that, please weigh in.
No, that was correct. That was the determination that was made. Obviously, it's still a public hearing. The public's present and able to sit and listen. We have a quorum, and it was, publicized as such. But with respect to making the record clear and not having this be a court of public opinion and solely based on any testimony or legal reasoning, we wanted to make sure that the record is clear for that purpose.
So basically what tell me if I'm wrong, but what you're trying to prevent is people coming up here just saying how wonderful the applicant is, as opposed to addressing the main issue of the appeal.
Yeah, I mean, if you want to call people that you have brought here to testify to the issues that are germane to the issues that are in factual dispute, we'll certainly entertain that, and we don't
Okay.
want to cut your opportunity to do that off.
That's fine. Thank you.
Okay.
Just by brief narrative, what the project actually is, an application for site plan was submitted some time ago asking for an expansion of the existing facility. It's located, as you know, at the intersection of Onondaga Road and Troy Schenectady Road, and it's just under 1 acre in size. It's more or less a rectangular shaped parcel. We have approximately 183 feet of frontage and 237 feet of frontage along Onondaga Road. The site is currently developed with approximately 1,300 square feet of commercial building, which includes gasoline, service station, and the sale of convenience items. The request is to expand the service area and add additional bays to the tune of approximately 2,000 square feet building addition, with expanded paved area to go along with that addition, and also to organize the parking in a better manner and to allow better access, ingress, and egress to the site. So that's just a very short summary of what is being proposed. So there are two central questions that are before this board this evening. One of them is very simply whether or not the legal non-conforming use of the sale of convenience items is actually that. Our position is that the sale of convenience items has been taking place since the 1950s, and we have affidavits to support that position. And I'll get into that into a little more detail. There were 4 affidavits that spoke directly to the issue prior to 1971. There were several of those, and then there were many that talked about subsequent to 1971, when the code went into effect, that confirmed that their use was not abandoned. So that's really the number one critical issue. Is there a legal non-conforming use for the sale of convenience items? The second issue has to do with whether or not we are prohibited from having 2 primary uses on the property, that being the sale of gasoline and the service station, as well as the convenience. And those are the 2 main issues, and I'll get into them in some detail. So the main job, from my point of view of this board, is to weigh what I'm saying the evidence is that supports my position versus what the town put in front of you to support their position that there is no legal non-conforming use for the convenience stores. And we went into great detail in our May 15th submission, where we tried to respond to each and every one of the items that the town put forth to support their position. And I'll go through those briefly for you. The first thing that the town said is the town has always recognized the subject premises as a gas station. And in 1969, the station applied for a permit to expand, which was denied. That was these are the things that they are saying support their position that there was no convenience sales. And our response to that was, first of all, it doesn't appear that that request for an expansion was in fact denied. If you see the letter from the applicant's lawyer that was attached to our papers, that permit request was withdrawn. It was not denied. The building permit was properly denied, but there was no denial by the Zoning Board of Appeals. So that issue has no relevance. Number 2, in 1984, the town says there was an appeal for additional signage with no mention of a convenience store. And our response to that is that request was merely for a trademark sign, and there was absolutely no discussion at the Zoning Board of Appeals about the use of the property. It was all about the sign. No discussion of gasoline service, no discussion of service work, and no discussion of convenience items. So therefore, again, that has no relevance. Number 3, in 1989, a canopy addition was proposed, and there was no mention of convenience sales. Again, it was a request for a canopy. Why would there be any mention of the sale of convenience store items? Once again, there was no mention of sales of gasoline, and there was no mention of sale of service station, vehicle service. In 1993, the town says a variance was requested, in 1972, a previous owner of 2339 Troy Schenectady Road opposed Stewart's Ice Cream's request to add commercial sales. And that somehow related to their position that shows that there were no convenience store. And what we indicated to the board was that the difference from what Stewart's was proposing, that being its bread and butter shop, that's what they actually called it. They have different varieties within their stores. The bread and butter shop was selling, the difference between what they had and what we had, or what the owner at that time had, was the difference between night and day. The bread and butter shop is like a small grocery store. Sells milk, bread, ice cream, snacks, canned foods, baking supplies, eggs, cereal, everyday essentials, and so on and so forth. And that's right out of their website, all of those items. That's a far cry from what Mr. Kaplan, who owned the facility at the time, was selling, and would have put him at a disadvantage, just as he explained to the board. In 1993, the planning board granted site plan approval for renovations to the gasoline service station with no mention of convenience sales. So the town keeps insisting that the lack of reference of convenient items is somehow proof that it didn't exist. But it's the same story over and over. Why would there be discussion about that when they're not talking about that? They're talking about renovations to the gasoline service station. There was no discussion about the other items at the service station. The fact that an application for outdoor renovations, outdoor, fails to mention convenience items is completely irrelevant and no proof whatsoever. The seventh item that the town relies on is that the fact that there has been a registration of the non-conforming use, which has failed to mention commercial sales, both for the prior owners and for the current owner. And our response to that was that every other gas station in Niskayuna has point of sales, has sales of convenience items. It's entirely feasible, I submit to the board, to conclude that neither the previous owner or certainly the current owner felt a need to register retail, as they, like the rest of us, assume that they go hand in hand, like they do in virtually every gas station they do in every gas station in Niskayuna, and virtually every gas station throughout the entire country these days. So it's entirely reasonable to assume that those two things went together. Now we get to the crux of the matter. I think that the town has indicated in their response that the affidavits that we submitted have limited probative value. So first of all, if they're admitting that it has some probative value, that's good. That's a good thing, because that's the key to the whole thing. We have the burden of proof, as you all know, to show that this use existed prior to 1971. We recognize that burden of proof, and we gave the board the proof that pushes this over the edge, and that's the affidavits. The town's claim that the affidavits have no probative value is just flat out wrong. The affidavits have the greatest probative value. They're the best evidence of what took place prior to 1971. And those affidavits came from people who lived in the area all this time, who have been there prior to 1971, subsequent to 1971, and simply are testifying to you that the convenience items existed. That's really the end of the discussion. To say they have limited probative value just ignores the fact that they're there. So we cited some cases, again, that we don't need to go into, but just saying that they have a constitutional right to continue the non-conforming use. He or she has a vested right which enjoys constitutional protection against municipal zoning power. And that's the case of New York case of Tier Properties versus Kitchen and several others that we cited. Then the town says, even if the applicant establishes that a limited number of items were sold at the property as a pre-existing non-conforming use, the Niskayuna Town Code prohibits the applicant's proposal to expand the types of items sold. The town is claiming that section 250-53A of your code prohibits expansion of non-conforming uses citing these historical denials of other applications. But these arguments fail for a number of reasons. Number one, as demonstrated, we're not adding a new non-conforming use. We're just simply continuing a pre-existing use. As I've indicated several times, our 50 affidavits, which is Exhibit D to our March 10th appeal, confirms the continuous operation of retail sales. It doesn't show merely limited items as was suggested, but substantial evidence of continuous convenience store operations alongside the gas station. Secondly, the zoning officer's historical examples that are in their papers are distinguishable, are readily distinguishable. They cite the 1973 mobile decision, which was denied adding new sales. The 1981 Van Antwerp case involved adding new sales of fresh sales, baked goods, etc. So both these cases are different than what we're doing. We're not adding, we're continuing. Most significantly, the town, in our opinion, mischaracterized the 1502 Bolton Road case from 1990, Balltown Road case. Based on the limited materials that were provided on that matter, the applicant there apparently did not seek to expand an existing retail use into a service bay as was stated. Rather, the ZBA's April 23rd, 1990 letter to the building inspector actually states this, quote, "The lot in question contains an existing gasoline service station, which is the principal use of the property. Section 4.1.5 shows neighborhood retail convenience store as a principal use in the CN district. If the neighborhood retail convenience store were added to the lot, there would be two principal uses on one lot." So unlike here, the applicant in that case was seeking to add a completely new convenience store, not extending a pre-existing use. And with the other cases that they cited that I've discussed, the 1990 decision is fundamentally different from the situation before you today. Third, and most critically, the town failed to address in its own recent contradictory precedent. In 2002, the same zoning enforcement officer advised the zoning board regarding the mobile gas station and Stewart Shops at Balltown Road, the same mobile gas station that was not permitted to add retail in 1990, and said, "The retail and service store gas station is a permitted use in the CN zoning district. An area variance for the rear setback of the proposed addition is required." And we attached the October 3rd, 2022 memo from the zoning officer. The town therefore treated the gasoline service station and the retail component as a single principal use, not two separate uses requiring two permits. Had the town applied to Stewart's the same interpretation it now applies to our client, their application would have been denied for having two principal uses on one lot in violation of the lot definition in section 220. The case of Mobile Oil, we went through in great detail, that established that a canopy added to an existing gas station did not require a use variance, because when the change is not fundamentally different, when they don't change the fundamental character by adding a canopy, then you don't need a use variance, you need an area variance. And the same thing is true here. We don't require a use variance. We're not changing the fundamental use and the character of this building that contains the same three things after approval of the site plan that it did prior to approval of the site plan. The next item that the town relied on has to do with the definition of gasoline service station, and this we certainly have a dispute about. The town has a narrow interpretation of what a gasoline service station definition is, but it contradicts New York state law, that narrow definition, and the definition permits the sale of motor vehicle accessories, which reasonably includes many convenience items that you find at gas stations, including oil, fluid, air fresheners, tire pressure gauges, etc. And most importantly, under the Exxon case, the definition does not expressly prohibit retail sales. So according to the Exxon case, if it's not is set forth as a prohibition,
Mr.
then
Palumbo,
it is allowed.
I just have a question.
Sure.
You have two separate arguments that you're putting forward, two main arguments, correct?
Yes.
Your reliance upon the Exxon case,
Hmm.
that's a second issue that you're putting forward. That's
That-
not, that is separate from a determination as to whether or not there was a pre-existing non-conforming use that predated 1971, correct?
Yeah, the reliance on the Exxon case is in direct response to the town's position in terms of the definition of gasoline service station. So if that does not relate to the convenience store, then you're correct.
Well, I mean,
Yes.
my understanding of your position, and correct me if I'm wrong, was that a gasoline service station includes incidental or ancillary uses. And one of those ancillary uses would be a convenience store. Is that your position?
That's correct. Accessory use, correct.
And so if the accessory use did include a convenience store, then you wouldn't have to rely upon being grandfathered in prior to 1971 as a pre-existing non-conforming use. Is that your position?
Say that again. Hit me one more time with that.
I'm saying if a convenience store is an accessory use to a service station, you wouldn't have to rely upon a pre-existing non-conforming use predating 1971 because a service station would always include a convenience store.
Right. There's two separate arguments there. Correct. That's one of them. And the other one is if they're not considered an accessory use, then the issue is whether or not they were pre-existing.
All right. So you're putting forward two separate
Correct.
arguments, correct?
Correct.
So the first argument relies upon, and I think you pointed out that you have the burden to establish that there's a pre-existing use prior to 1971 of a service station. Yes? Or
Of the
store.
convenience. Yes.
Okay. And so what is the definition of a convenience store? I didn't see, is there a definition of convenience store in our code?
There is not.
Okay. So what are you defining a convenience store to be?
Well, typically what they're referred to as a point of sale, and a point of sale typically includes the sale of potato chips and orange juice and convenience type items.
Is there an intensity of those sales to establish the convenience store?
Is there an intensity?
Yeah. Do you have to sell a certain amount? I mean, if we have a box of Slim Jims on the counter, does that establish a convenience store?
That would be an interpretation that you would have to make.
Well, I'm asking you your interpretation.
I would say that that's not the situation here. So
Okay.
it's not relevant.
All right. Well, so that's what I'm asking you. How much in sales, whether it's volume of sales or number of items, would you have to have before you establish that a convenience store exists?
Again, that's an interpretation that this board is going to have to make. It's not something that I can answer for you.
Okay.
The answer, if I was going to give you an answer, I would tell you that the sale of anything is a sale of a convenience item. But that's your
Okay.
your job, and it's not the situation because there's been more sales than one potato chip.
Okay. Well, I didn't say one potato chip. I think I said Slim Jims, but in
Whatever.
any event, prior to 1971, what was being sold there?
All the things that we've talked about, potato chips, pretzels, convenience items. I don't have a whole list of what was there. Certainly my client could tell you.
Well, I mean, I think in your affidavits, you indicate that cigarettes were being sold there. Yes?
I don't remember if that's in there or not, to be honest with you. Did you sell cigarettes there at one time? Yes.
Okay. So
Yes.
prior to 1971, there were cigarettes being sold there.
Yes.
Okay. So you had to have a retail license prior to 1971 for the sale of cigarettes. Yes?
It was in a vending machine. So if you needed a license,
I think you still need a license, even if
Yeah,
you're selling it
could
in a
be.
vending machine.
mm,
So do you have any evidence of the sale of those types of items prior to 1971? A license that predates 1971?
come on up and answer that. Just identify yourself.
Yes, sir. If you could just state your name and address for the record.
Arinder Kinga, 2140 Cayuga Court.
Okay. And you were going to address the issues that were what was being sold prior to 1971 at the location.
First of all, I wasn't here in 71, but
Okay.
the facts that people are signing affidavits to substantiate that there was items sold. I don't know, a vending machine back then needed a license of personal is hosting a vending machine would need a license. I think that's the vending machine's responsibility to have a license.
Okay, are you currently selling cigarettes? at the location?
Absolutely. Lotto, lottery tickets, cigarettes, chips, soda, candies,
Okay.
you know.
And do you have any evidence of those items being sold prior to 1971? Photographs?
The affidavits I do.
Okay, I understand the affidavits, but other than the affidavits, photographs?
Well, affidavits are very substantiating
I-
evidence, I think.
That's not the question I asked. I asked,
I was.
okay, is there anything, okay, I'll just simplify it. Is there anything other than the affidavits that you have to substantiate sales of convenience store related items prior to 1971?
No, and that best evidence is the affidavit.
Okay, I understand that's your position, but I'm asking, just want to flesh it out to make sure that I'm not missing anything, that such, that such evidence does exist.
I don't think any vending machines exist anymore, so we can't even go back to them to see if they can give us some paperwork on those.
Do we have, in terms of the affidavits, all of the affidavits are identical, correct?
Yes, all except one, I believe.
Okay, and who prepared the form for the affidavit?
Did you prefer?
We,
Okay, so the appellant prepared the forms. The people that signed them did not prepare the affidavits. Okay,
prepared, Mr. What?
all right. All right. I just wanted to interrupt, Mr. Palumbo. I want to give you a full opportunity to tell your entire position. I just wanted to make sure that I had an understanding that there's two separate issues. One is more of a legal interpretation, and the other one is a kind of a fact-based interpretation. So I wanted to stop you with respect to the facts as to whether there was a pre-existing non-conforming use. And I think it might be helpful to first address those issues and see if there's any members of the board that have questions of you relative to pre-existing non-conforming uses at the location predating 1971, and then give you an opportunity to go on and address the Exxon case and your argument with respect to that. Are there any other questions of the board that have any members of the board that have questions relative to that?
Just one clarifying point. There's no real dispute that the gasoline service station was the pre-existing non-conforming use. The real question is whether or not the convenience store is part of that use and can be considered as part of that use, so you can continue operating it here. Do I have that correct?
That's correct.
Okay. So it's less of a question of whether or not there's any non-conforming use. It's just a question of whether or not the use of a convenience store is an accessory use to the agreed upon non-conforming use, which is the gasoline service station.
Correct.
Okay. If I can clarify that also, is there any dispute among the parties about whether or not this is actually a non-conforming use at the site? I think we're all in agreement that it is a non-conforming use, or is there any dispute over that?
That the convenience,
That the gasoline service station is? a
no, I think the
non-conforming
town
use?
has conceded that the gas station is a legal non-conforming use.
Okay. One other factual question that I'll let you get back to
No,
it.
it's fine.
Are the proposed changes going to be greater than 10% of the usable floor area of the facility as it stands today?
Yes, that is one of the variance requests.
Okay.
To expand the greater than 10%.
Very good. Thank you.
And your position with that is you would need an area variance as opposed to a use variance.
Correct. Correct.
Okay. I think I bifurcated and I kind of cut you off before you went into the Exxon case and your argument with respect to that.
Well, let's go back and talk about the Exxon case. The Exxon court established and relied upon what I say are fundamental principles of zoning. That these fundamental principles apply regardless of the specific ordinance language. And I think that's accurate. The court recognized in Exxon that zoning ordinances which are in derogation of common law must be strictly construed against the zoning authority, which in this case is the town. It further emphasized that the issue is not whether the use is permissible, but rather whether it's prohibited. And that's what we were talking about earlier. Your ordinance does not prohibit it. Well, the principle applies in our case directly. The town's definition of gasoline service station does not include the exact phrase uses accessory thereto. It does not expressly prohibit it as well. Then the Exxon court talked about the changes that took place in gasoline stations over the years since 1987. And we went into detail about that. But the main issue is that there's no zoning district in Niskayuna that permits gasoline service stations explicitly allows any form of retail as an accessory use. They're permitted uses, both of them, retail and gasoline service. They're not accessory. So what that means to me is that this reality that reveals, like, the town, like the Exxon court, has tacitly recognized that convenience store operations are an inherent part of modern gasoline service stations, and even expressly decided that in the case of the 2022 Stewart's application. That's what they held. The town's position here would now create an untenable contradiction. If convenience stores at gas stations truly constituted separate principal uses, then every gas station in Niskayuna with a retail component is operating in violation of the lot definition, prohibition on multiple principal uses. Every one of them would be in violation. The fact that these operations have been permitted and continue without any enforcement demonstrates that the town understands, at least in practice, that convenience retail is intrinsic to gasoline service station. That's what we get out of the Exxon case, and that's what we get out of the town's position with their decision in the Stewart's application. The next item that the town relies upon in support of their position is that the town has consistently determined that the definition of gasoline service station does not include the right to sell retail products. And I don't mean to hammer this, but as we already demonstrated, the town has not consistently made that determination. In May of 2022, that, as I indicated, Laura Robertson, who denied our application, advised the ZBA that the retail and service station gas station is a permitted principal use in the CN zoning district. That demonstrates that the town considered retail and gas station operations as a single principal use, not two separate uses. So that addresses the second half of what I started with. The lot issue, the two primary uses, and the issue of the affidavits and the pre-existing non-conforming use. So the only other thing that we talked about in our response to the town was their final statement that the applicant's gasoline service station can be distinguished from every other gasoline service station because we're the only legally pre-existing non-conforming gasoline service station in our one zone. That much is true. We are the only one. But that analysis fails for several reasons. First, the assertion that other stations operate with special use permits approved by the town board isn't material to this issue. Whether they're designated as a special principal use or simply a principal use, both gasoline service station and convenience store uses are still principal uses under the code. And that's the key. They're principal. If the town indeed has granted special use permits allowing both gasoline service stations and convenience stores to operate on the same lot, then all those stations are operating with two principal uses on one lot. The very arrangement that they claim is inappropriate in our case. So there's been no evidence that these special use permits explicitly authorize both uses as separate principal uses. There weren't any copies of permits that were included with the town's response to our appeal. And more likely, as demonstrated by the 2022 Stewart's decision, the town has consistently treated gasoline service stations with convenience components as a single integrated use, except in our case. So with that, I'd be happy to answer any questions you might have and hope that I didn't lose you.
Mr. Palumbo, I just have a couple points I'm looking to clarify. With respect to our interpretation of the Niskayuna zoning code, it's our obligation to strictly construe the code and resolve any ambiguities in favor of the applicant, correct? You would agree with that
Yes.
position?
Yes.
You'd also agree with the position that we don't have the ability or authority to extend any provisions of the Niskayuna Code by implication, right? You would agree with that? We can't imply uses that aren't explicitly stated in the code.
Correct.
Okay. And you would also agree that the definition of gasoline service station does not explicitly include a convenience store or any accessory uses in the Niskayuna Town Code, correct?
Doesn't include and doesn't prohibit.
Okay. It doesn't prohibit, but you say it doesn't prohibit, but you're relying upon the Exxon case. And in that case, the code specifically said any uses accessory thereto. And I believe the court in that case said that that was an inclusive type of language, but we don't have that inclusive type of language in our code, correct? With
Well, I
respect
don't-
to the definition of a gasoline service station.
The Exxon case talked about exclusivity because they said that if it's not specifically prohibited, then it's allowed.
Well,
That's
they
the
said that in
Exxon
the
case.
context of the language of that particular code section in New York City that specifically had language in it that said uses accessory thereto, any uses accessory thereto. And I think the court in that decision, I've had the opportunity to review that decision, reflected on that language, that specific language being inclusive. And in our code, we don't have that inclusive language. So if we were going to strictly review the language in our code section without reaching, implying things, we wouldn't be able to reach that determination by a review of the language of gasoline service station. Is that correct?
I'm not sure if everything you just said there describes the intent of the Exxon case. I know that the codes are different, but the essence of what the court said in Exxon still remains that if it's not specifically prohibited, and I understand that there's different language, then it should be allowed. But that's really getting into an area that is not as important as some of the other areas that we've discussed.
So your primary argument is we have this pre-existing accessory use. It's predated 1971. That's the main thrust of your argument.
Exactly.
And we have the affidavits, and they should be factually sufficient to substantiate our burden of that use.
Right, because the code is 3 years old now, 1971. It's difficult to try to find any type of pictures that, as you suggested, because it's been so old and they're different owners. If it was the same owner, perhaps there would be additional information. But again, what's the best evidence? The best evidence is someone's coming in here to tell you that these things were sold.
And are any of those people present this evening with you?
I don't know.
Okay.
I couldn't tell you.
Okay. All right. Okay, sir, you would have to come up and, Mr. Palumbo, do you want to call anybody
Sure.
factually forward?
Yeah. Come on up.
Test that he's
Okay, first, sir, hold on one second.
David Scott.
Okay, and what's your name and address for the record?
David Scott, 805 Maxwell Drive.
Okay, hold on one second. Elena, are we gonna swear people in?
If he's going to give testimony, yes.
Okay. Sir, do you want to give testimony on behalf of the appellant this evening?
Yeah.
Okay. So we're gonna swear you in to testify under oath. Okay, so can you raise your right hand? You swear that everything you're gonna say is the truth, nothing but the truth, so help you God, or so affirm?
Yes,
Okay. All right. So what do you want to tell us about, well, first of all, sir, when did you start residing in Niskayuna?
15 or 16 years ago.
Okay. After 1971?
Correct.
Okay. And what do you want to say, sir?
He has been selling convenience items since then.
Okay. Since the time that you
Since the
resided?
time I moved here.
Okay. Anything else you'd like to say?
I just want to attest that he is selling them.
Thank you, sir. All right, sir, if you want to come forward. Yep.
My
Sir,
name is Bill Leader. I live at 18 Norwood Way,
okay, sir.
Niskayuna.
Do you want to offer testimony?
I want to offer testimony. Please swear me in.
Okay, can you raise your hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God, or so affirm?
I do.
Okay.
So I lived in Niskuna since 1947, with the exception of 10 years in Clifton Park. I am probably unusual because in the mid 60s, I worked at that gas station. And I will attest to the fact that we had a soda machine and we had a vending machine that sold cigarettes.
Okay.
I also worked at the gas station next door, which doesn't exist anymore, and they also sold the same items.
And the soda machine, and you said a cigarette machine?
Vending machine for cigarettes, a vending machine for soda. It was a Coke machine.
And what was the time period that you
1963, 64, when I was in high school.
okay. Anything else, sir, you want to?
No, that's it.
Thank you.
Thank you.
Sir, you want to come forward? State your name and address for the record.
My name's Joseph O'Brien. I live at 2370 Algonquin Road.
Okay, do you want to offer testimony?
I do, yes.
Okay, you raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth to help you God, or so affirm?
Yes, I do.
Right.
Okay, so I've lived in Niskuna since 1991, lived at the 2370 Algonquin address on and off since 2007. I also, like the previous gentleman, worked at that location from a period between, I would say, 2010 to 2014, and then on and off since then, pretty much over the last like 5, 6, 7 years. I too can attest that they sold convenience items. I checked the expiration dates on all that stuff. I had to pull it off the shelf in the back and restock it. I had to count all the cigarettes at the end of the day. And I would say, even though I can't attest to what happened in 1971, the infrastructure of the building, it is my understanding, has not changed since that time. And it would, to my knowledge, confirm that it was a building that sold convenience items. I don't know what else could have been going on in there. So that's all I have to say. Thank you.
All right, thank you.
Just as a matter of procedure, I don't know if any board members want to ask any of the witnesses questions as they testify as well, but
Were there anybody that had anybody on the board that had questions for any of the witnesses that wished to ask questions of those witnesses?
Yeah, Chairman, I have a question for the two gentlemen who did work there.
Sir, can you come back? You come back up. Yeah, you can stand right behind. So just for the record, just to clarify your name and address one more time.
Bill Leader, 18 Norwood Way.
Okay, you're still sworn, sir?
Mr. Nieder, I do want to ask, when you worked there, the question has come across the board about licensing for selling cigarettes. Are you aware of any such procedure when you were working there?
As a 16-year-old, I was not aware of any licensing.
Okay, thank you. And I would ask the same question of the other.
Say my name again.
Yeah, just for the record.
Joseph O'Brien.
Uh,
I can speak to that. I do know that they held a license to sell cigarettes. I know that especially because the county of Schenectady once sent a child in there to see if I would sell them a cigarette without an ID, which I did not. We were given a certificate stating that we in fact did not sell cigarettes to that gentleman, and were able to keep the license.
And again, what time frame did you work?
This was about, so it was around, I would say 2010 to 2014, and then probably again from 2018 to the present, on and off. I will work there on occasion for him when they need help.
Thank you.
Yeah, okay.
Ready?
Yeah, I've got a question for the, sir, I can't
Mr.
remember
Leader,
your name.
Mr. Leader. I think it's Mr. Leader.
Mr. Leader, yes, thank you.
Yes,
You said that you worked at the service station, is that correct?
I did.
So did you have access to the vending machines, the soda machines and the cigarette
If I
machines?
put money in them, yes.
So did you take money out of the machines?
No.
Did you stock the machines?
No,
Okay. Were you aware of any other organization that came and collected that money or stocked the machines?
not to my knowledge.
Okay, thank you.
I have another question for you, sir, before you go. Were the soda machines and cigarette machines inside or outside?
The soda machine was outside, the cigarette machine was inside, to the best of my recollection.
Okay, thank you.
Is there anyone else? Okay, Mr. Palumbo, do you have anything else? I'm sorry, you wish to testify? If you're gonna testify, come forward, please. Okay, and just to clarify, sir, State your name and address for the record.
My name is James Gamindi. I live at 1723 Union Street.
Okay, sir. And are you going to offer testimony on behalf of the appellant?
I'm not quite sure what the reasoning. I mean, you know, they've given testimony, and I think most everybody in here at one time or another.
Okay, sir.
I'm just trying to get an idea, because here's the thing. I came here in say 1999, and I've been living here in Niskayuna for quite a while. And in the times that I've been living here, and there have been, my recollection, like 2 or 3 other owners of that service station, but I've stopped in there and bought gas. I'm not a real big convenience store type of person, but I have bought like a soda in there.
Okay, sir.
So I'm not sure or what the testimony is doing, other than the fact that I think we're all kind of clear on the point that at that gas station and most gas stations.
Sir, I understand. I understand. I just don't want to. Now you're just making arguments on behalf.
No, I'm not making an
So-
argument. I'm just trying to follow through as to
Yeah.
what, you know, I understand. You
I don't
want
want
to
to
try.
stop you,
Okay,
sir.
I'm
If you
sorry.
want to offer testimony, let me just swear you in. You can offer your testimony.
Okay, thank you.
Okay. So what's your name and address for the record?
It's James Gamindi. I live at 1723 Union Street.
Okay. Can you raise your right hand? Swear to tell the truth, the whole truth, and nothing but the truth. So help you God, or so affirm.
Yes,
Okay. And you're going to offer testimony on behalf of the appellant here.
just that over the past, you know, my time and period here from 1999 to here, I have bought gas at that gas station. At that time when I bought gas, feeling the need, I'll buy a soda or a candy bar. Not so much the chips or anything like that, but so you know, if you're looking for like a history of the fact that people have gone in there and bought items there as a convenience store.
Yeah.
Yes, it pretty much fits the, you know, general rule of
Thank-
thumb for all the gas stations along Route 7, Bulltown Road, Upper Union Street, all the way down to Union Street, you know, down Erie Canal or whatever. It's if there's a gas station, they're going to be selling soda and candy bars and sundry things. In terms of the convenience for the store, I mean, they don't sell milk, they don't sell eggs. It's just pretty much that. You go in, you buy gas, and you buy a snack, you buy a drink. If you're into fishing, for some odd reason, Harry stocks night crawlers.
Great.
But it ain't Dick's Sporting Goods. It ain't, you know, it certainly doesn't do business, compete with Stewart's in that regard, because Stewart sells a lot more night
Understand.
crawlers.
Sir, I think we've got your testimony. I appreciate it.
Okay.
And thank you.
Yeah, but I was just trying to follow along. I mean, I think we're all kind of clear on the fact that most gas stations, most service stations have a accessory outlet because people like to buy snacks and drinks and things. I think if you've been living here in Niskayuna, the possibility exists that more than likely that you all have stopped in there at one point or another. You know,
Okay.
might not be your favorite gas station, but you stopped in there and
All right,
maybe
sir.
bought a pack of gum or something like that.
Sir, I appreciate
thank you.
Your point's taken.
Okay,
Okay. Thank you.
thank you very much.
Mr. Chairman,
Yes.
I'd just like, for a point of information, I have, for 15 years, bought cigarettes and coffee and gas from the appellant. So as that matters, I think that,
Yeah.
that's it.
So not to get off too off track here. I understand that the testimony generally is that people in the room have bought convenience items from the location. I think the main issue and what we're trying to really hammer down in is the use or the pre-existing use of the property prior to 1971. And Mr. Leaders offered testimony as to that. If there's other people in the room that have testimony as to the use prior to 1971, that would be particularly instructive to this board. Okay. Understood. Okay. We're not going to have it going back and forth. Mr. Palumbo, do you have anything further?
We have a gentleman that's been living there since 1966 down the street, and he's just a little older, but we can transport him here and he'll be glad to testify. Since he was 21, 1966, he's been living down the street from the gas station, that he has seen items of convenience store available in that store since then.
Well, and
Mr. Workman is his name.
again, there are
at least 4 affidavits prior to 1971, which are material as well. I just want to go back to how we started this discussion. This board has to make a determination as to whether or not the pre-existing use is there, which means you have to look at what the town has submitted versus what we've submitted. And I would suggest to you one more time that what we've submitted far surpasses anything that the town submitted in opposition. Big number, and then we don't need to go through them again, but the fact that convenience stores were not mentioned when it came to canopies and signs and so on and so forth, that's not proof. That's all I have.
Thank you, Mr. Palumbo. Does
Thank
anybody
you.
else have any questions from the board for Mr. Palumbo?
Just a quick question.
Sure.
I don't live that far from the gas station and I have put gas in there and I've worked with Robert on mechanic. And again, I'm not sure if they have a convenience store or not. They probably do. The question I have, the legality of the convenience store. And if it's not a problem, why not choose a use variance and complain if it was non-conforming before 1971? I'm not understanding what is the argument, your argument, not to have. a
Sure,
use
that's a good
variance.
question. And I'll answer it. The difference is in the standard that's applied to each of those issues. Our obligation, as you know, this evening is to convince this board that the sale of convenience items took place prior to 1971. If the board believes and adopts the proof that we presented, then we continue to sell convenience items. That's it. We don't have to show anything else. If we file for a use variance, it's a much more difficult process. We have to show that my client cannot realize a reasonable rate of return for any of the uses that are allowed in the current zoning district. It's a tough standard. We have to show it by financial documentation, essentially saying that he's not making any money. Now, can he do that? Maybe not, maybe yes, but it's a much different standard than the proof relative to the issue of non-conforming use.
But even if you have an area variance, you know you can't build more than 10% on non-conforming, right? And that you have to come back and try to.
We have already filed that application asking to expand greater than 10%. And the argument there is it's an area variance, so we'd have to show, the benefit to the applicant outweighs any detriment to the health, safety, and welfare of the neighborhood, and then apply the 5 factors that go with it. But yes, we're aware of
Now,
that.
let me ask you, there was a mention somewhere that they did do some remodeling to the gas station at certain year, 80s or something. Did that was part of that 10%, the non-conforming remodeling?
I'm not sure what you're referring to.
Did they ever expand that gas station?
No.
Okay. So if you were to be allowed to expand the gas station right now,
Yes,
for non-conforming, you're allowed 10%.
correct.
And what you're looking for is more beyond 10%. What is you're looking for? What's the percentage? I know you mentioned
it-
1,300 square feet right now, what you have or something.
We're adding a substantial amount so that we can add 3 separate bays. And I don't remember what the percentage is. It may be close to 100%. I don't remember the number,
Okay.
but it's a substantial number.
Okay. Last question for you. Do you have anything legally with the town for your client to have a convenience store? We know we have affidavits of 50 people. I can even give an affidavit that they sold stuff there. But do we have anything legal from the town to show us that there is a convenience store? I can tell you, I could go buy something at a store, but I don't know if it's legal. Do you have anything? Just answer me yes or no. Anything legal to show me that shows with the town that this is a convenience store and a gas station and an auto repair?
What we have, you've already mentioned, are the affidavits. If the affidavits if this board determines that the affidavits are sufficient to establish that convenience items were sold prior to 1971, then that's the legal documentation.
We don't have any.
We don't have anything else. We don't have
Okay.
pictures. We don't have, people,
Thank you.
we don't have videotape of people walking out with convenient, we don't have anything other than that.
Thank you, appreciate
Mm.
the answer.
Mr. Chairman, I just have a couple quick questions.
Yes, Mr. Dolman.
Thank you. This might be a question for both Laura and the appellant here. Is it accurate to say that the infrastructure of the building hasn't changed since 1971? The basic layout of the building hasn't changed?
The footprint of the building hasn't changed.
Okay.
My client says it hasn't changed since 1948.
Okay, thank you. And would it be reasonable to assume that sales tax was collected on all of the convenience sale items?
Yes,
Okay, thank you.
you're welcome.
Mr. Chairman, I have a few questions for Mr. Palumbo. In the short environmental assessment form application that is submitted as part of your evidence, it is signed on September 16th, 2024. And it does list the zoning board use variance as a required part of the approval process. Can you explain why that's listed there?
Yes, Brian Sipperly is the gentleman who prepared the application originally, and he was relying on the information that he received from the town relative to the issue of use variance and area variance. That was before I became involved. Once I became involved, then we had discussions with the town, felt differently, and that led us to today. But that's why the answer was the way you described it.
And Brian Sipperly performed what service for the applicant?
He prepared the application for site plan along with the environmental assessment form.
Is he an engineer?
He's an engineer, yes.
Okay. Another question about that seeker application. Item 17, will the proposed action create stormwater discharge either from point or non-point sources? Will the stormwater discharge flow to adjacent properties? It was answered yes, so I just want to ask briefly about that.
I'm
We're-
just
we're-
going to interject. I think that might be more appropriate for a later discussion if there's an area variance that comes back as to the actual interpretation of the issues before this board. I don't know that question is germane to that.
Okay, I appreciate that.
Thank you for clearing that.
Okay, and I think one more question. As we look at the ordinance, at the zoning ordinance, the way that it was written and been amended over the years, the R1 zone does state specifically that convenience store is not a permitted accessory use. Just looking at the list here, and I realize that you are trying to convince us that it was a primary use or principal use at the station. Is that correct?
All I'm trying to show is that it's a legal non-conforming use. Relative to the issue of whether or not you can have two primary uses on the lot, then my position is yes, we have two primary uses because it's the same thing as every other gas station.
I beg to differ on the same as every other gas station because there are others in different zones. So
They're in different zones, but they're both considered to be primary uses.
as a principal use in a different zone, it has different definitions. So that's my interpretation at this point. So I just wanted to clarify what argument you were making.
Well, that is the argument that we're making. We need to be treated exactly like the others. The fact that there's different zonings is not germane. That's our position.
Thank you.
Any other question? All right, Mr. Palumbo, thank you. I think we're gonna next have give the town an opportunity to state their position. And for the town, I believe Mr. Hess is going to be presenting. Mr. Hess, can you just state your name and business address?
Good
for the
evening.
record?
My name is Rob Hess. I'm an attorney with the law firm of Sullivan, Hess, and Youngblood. I live here in Niskayuna at 117 Comanche Trail. I have previously been town attorney, but my current role with the town is I'm just outside counsel. So typically I'm outside counsel for the planning board, but tonight I've been asked to present the town's position vis-a-vis this application. So for starters, and I know we've spent a ton of time in this already, but the issue is not the expansion of the building itself. It's the fact that on the plans that were submitted, there's an area of approximately 680 square feet that's designated as a convenience store. And that designation triggered the denial from the town's Deputy Zoning Enforcement Officer, Laura Robertson. And she made the determination that because of that designation of the convenience store use, we'd need to have a use variance. So that's what's on appeal. There's 3 sections of the town's zoning code that are relevant, and I'll sort of deal with them as we go along. But sort of what the big thing is, what is the state, or what was the status of this property in 1971 when our zoning was enacted? So I'll get to the affidavits, but the town's position is that for more than 50 years, we've been dealing with this property as a legally pre-existing non-conforming use, just as a gasoline service station, that we have never dealt with it as a pre-existing non-conforming use as a convenience store. And, so the applicant went through the various applications that we referenced in our papers. This property has been before the board, or maybe not necessarily the zoning board, but the town has dealt with it on 4 different occasions. And while those applications weren't for a convenience store, they're relevant on the issue of how both the town treated the property as a gasoline service station, and also how the applicant held itself out just as a gasoline service station. So one of the things I'd like to direct your attention to is the application that was submitted. It's our Exhibit A. It's page 116. In any event, what it is, in 1969, the then owner of the property, Shalom Realty Corporation, submitted an application, and what they were trying to do is expand the property and add an addition of approximately 20 by 30. And in the application that's signed by the applicant, Fred Kaplan, as president, held himself out. The present use of the property for a gas station is a long existing non-conforming use. So it's not just the town who has considered it as a gas station, it's that the applicant, or the owner itself, at this point, Shalom Realty Corporation in 1969 was holding itself out as just a gasoline service station. But that's not the only time. Like if you looked at the applications in 1984, 1989, 1993, each of those applications, both the town and the owner held themselves out as just being a gasoline service station. So in addition to that, the town has other records which indicate that the owner considered itself to be just a gasoline service station. So the town maintains a registry of non-conforming uses. On an annual basis, it requests property owners who have non-conforming uses to register. We send out a 1-page form. They send it back. So we have the ones that were submitted. It would be Exhibit G, pages 161 through 175. So between 2010 and 2024, we've got responses from the owner, which indicate that, well, first of all, the question is, please describe in detail all those aspects that are in conflict with the current zoning ordinance. And the response from the owner was gasoline service station. And then eventually it was gasoline sales and auto repair. And then finally, for the first time in 2024, the applicant, as the then owner, current owner, added convenience store as one of the ways that the aspects that it conflicted with our zoning. So again, we've got that, like statements by the applicant. We also have, minutes from a ZBA meeting in 1972, where the then owner, the same person who made the application in 1969, Fred Kaplan, objected to a Stewart's that was trying to locate across the street in the building that's currently the Berkshire Hathaway building. That used to also be a gas station. They wanted to become a Stewart's. Fred Kaplan objected, saying it would put him at a competitive disadvantage. So that's why I can say, even though the applicant has sort of poo-pooed the town's records, we have a lot of them which show that not only the town, but the owner of the property believed that it was a non-conforming use just as a gasoline service station. I'd like to address the affidavits. We spent a bunch of time on them already. So for starters, even though there's 50 of them in your package, really only 4 matter. So the 4 that were signed before 1970, for people who had knowledge before 1971, those ones at least address the right issue. So let's be clear. The form affidavit was prepared by the applicant. So he wrote in what they were selling, and the applicant, or sorry, the person signed what was put in front of them. So I think there is a little bit of leading the witness. And I believe that, especially in light of the application or the testimony that we had tonight from Mr. Leader. So Mr. Leader testified that there were soda machines and vending machines. So the affidavits that were submitted are consistent with that limited use. But the reason why, so there's lots of things that the affidavits don't say. So they don't say that they were selling milk, and it doesn't say that they were selling ice cream or bread or eggs or things that we would associate with a convenience store selling. It's consistent, that affidavit, with soda machines and vending machines. And if that's all it was, it's not even clear that it was the owner of the property who was benefiting from that, right? So you could have a vending machine. We had one in Town Hall until recently. The town didn't operate that vending machine. Someone came in and took care of it. It wasn't that the town was selling stuff, or if you go to your doctor's office or that type of thing, those aren't convenience stores. This is Town Hall. We just happen to have a vending machine.
Sorry, we're not having any
So listen,
conversations from the audience, please.
what the zoning board needs to do is to weigh the evidence on this pre-existing non-conforming use. And the issue there is we've got affidavits that were prepared by the applicant about something that existed more than 50 years ago versus the town's records, which were created contemporaneously. So the records that we have from about what it was in 1969 were created in 1969. And the records about how it was in 1984 were created in 1984. So I think that has significantly more probative value, because we weren't like fishing for an answer. Like, we just recorded what happened. The applicant has spent a lot of time presenting the position, both in their written submission and tonight, that that the town is treating this property different than every other property that maintains a gasoline station and a convenience store. And it's not that we're treating this property differently, it's that the facts are different. So let's zoom out a little bit. So municipalities are authorized to create their own zoning statutes. And let me go to a different spot, sorry. Looking at this property, it's not just that it's a non-conforming use, it's that it's a non-conforming use in R1. So all of the other gasoline service stations which have the combined or have both gasoline service station and retail are in either the CN commercial neighborhood commercial district or the CH highway commercial district. And that distinction is critical because in both CN and CH, retail is an allowed use. Like you don't need special permission to do that. You get it as a right. And the gasoline service station can be allowed with special use permit. So the town's zoning code, like there's been a lot of, the applicant is very hung up on how we've dealt with Stewart's compared to this property. And the distinction and why it's different is that Stewart's had a special use permit and retail, but both were granted by the town board, our duly elected officials. So are there special uses, special rules for special use permits? Sure, because it's the town board that's doing it, not you. It's not, it's elected officials. As opposed to this property where neither the retail nor the gasoline station is an allowed use. So this property would not be eligible for a special use permit. Like the town board, even if they were so inclined, would not be authorized to give a special use permit for this property, and retail isn't an allowed use here either. So
Mr. Harris, may I ask a question on that?
Of course.
So I think the appellant's argument on that is the limitation to two principal uses on one side comes from the definition of the term lot in the zoning code. Is it true that in Stewart's position where they were applying for a special use permit, the defined term lot does not apply in that instance?
Yeah, so good question. So the issue is that the zoning code 220-57 specifically allows the town board to issue a special use permit and combined uses so that they can, so whether we look at it as combining uses or allows them to have two principal uses on one lot, there's a special section of the town code that specifically authorizes the town board to have done that, which is how we have each of the other combined gasoline stations and convenience stores have a special use permit. So there is one other thing I'd like to point out about that, which is that the applicant has said that there are no other just gasoline stations that don't have convenience, that's like it's just de facto what happens. But in fact, there is at least one. And the one that I'm thinking of is Niskayuna Tire, which is just across the street from the Stewart's, is just a gasoline station.
No, sir, not now.
What's that?
Not now, not Mr. Hess.
Okay.
We're not taking any statements from the audience at this point.
So yeah, so we would direct this board's attention to Town Code 220-57, which reads, the town board shall have the right to issue or deny a special use permit for all special uses in respective districts. And they can combine uses. So that's not a violation of our town code. In reference to this idea that gasoline stations by New York state law get to have accessory uses. The applicant has cited the Exxon case, it's Exxon Corp v. Board of Standards. So in this context, it's super important to understand what's going on, which is that if you zoom out, towns can have their own zoning codes and they're different, which is why Niskuna's zoning code is different than Clifton Park's and Colonies, neighboring communities. But as you can probably understand, our zoning code is significantly different than the New York City zoning code. So in the definition for the automotive service station that was at issue in the Exxon case, it specifically allowed gasoline stations to have accessory uses. So the court wasn't making a determination about whether accessory uses were permitted. It just was making a determination about what an accessory use was. And then separately, it didn't say that convenience stores were accessory uses. It just remanded it back to the zoning board for them to make a determination as to if it was an appropriate accessory use. So I guess in short, I just don't think Exxon applies to Niskuna's situation.
If you have a question.
Mr. Chairman, may I?
Mr. Doman, yeah.
Yeah.
So you've said that the town has never dealt with this property as a convenience store in the past. So it's been exclusively as a gasoline service station, correct?
Correct. Well, that's what the town records indicate. So yes, that's my position.
All right. So my question for you is, has there been a case presented where that would have been germane? My thinking, let me explain my thinking on that, is that if I was, say, asking if I could put a canopy over my gas pumps, whether the town let me or not, it wouldn't necessarily be germane whether I also sold Coke, would it?
So I think it's a good question. I think your position's insightful. The question then is, what we have shows they've held themselves out as a gasoline service station. Whether or not there was a vending machine there, it wouldn't necessarily agree to say that, but the records do reflect for all of these situations that they were holding themselves out as a gasoline service station, and that was the use of the property.
Okay. You made the statement that the affidavits were pre-filled out by the appellant and that the people were just signing their names to what was on there.
Correct.
Do you hold that any of the affidavit signers were, or does the town hold that any of the affidavit signers were misled or coerced?
No, definitely not. Our position is actually different than that.
Okay.
I think that they're sufficiently vague that, for instance, the fact that there were vending machines there, if that were the case, would be consistent with the affidavit they signed. So no, I don't think they were. I think that what's difficult about this case from a public's perception is like a lot of people think this is a community resource. So I don't think anyone was coerced, nor does the town have anything against the applicant. We just need to apply our zoning code.
So it seems to me that and I'm not an attorney, so it seems to me the primary question that's in front of us is, does a gas station necessarily include point of sale?
So I don't think that you can get to that actually, because our statute is super specific about what a gasoline station can do.
Okay.
So if, in order to get there, my position is you can't get there as an accessory use. You would have to get there as a primary use that existed in 1971. Because our definition does not allow that. Like, it's super specific, and you can say what you want about the Niskuna zoning code. Having been town attorney, I know it has some deficiencies, but it's super specific about what can be sold and what can't be sold.
Okay.
Can you elaborate on that a bit? So I'm looking at the definition of gasoline service station.
Yeah.
And it clearly is defined as structure used for the sale of gasoline, motor vehicle fuel, oil, lubricating substances, sale of motor vehicle accessories, and may include lubrication, washing, and other self-servicing matters. But it is to the point the applicant made, it's not clear that there's other uses, similar uses that are culturally or typically consistent with that, such as convenience stores, would not necessarily also be allowed as an accessory use in that. So yes, I understand how the definition of gasoline service station is specific. Is that all you're basing that on, or is there more in the code that
Well, the
makes
code,
it so that an accessory use like a convenience store could not be applied to it?
well, the code makes a special allowance for retail. So for instance, retail is not allowed in R1 at all. So like retail is a separate allowed use, just not in R1. So I would say that the convenience store falls under a totally different category in our zoning code, and that would be retail.
Mr. Hess.
Yeah.
You mentioned between 2010 and 2024, the applicant, the town sent them a form to tell us what kind of business he's running.
Yeah, the registry of non-conforming uses, yes.
Yes. In that registry, when he sent it to the town, between 2010 and 2024, never mentioned convenience store. Is that correct?
In 2024, convenience store was mentioned. So
In
prior to that,
2024 was mentioned.
right. And just so we're clear, the current applicant wasn't the owner of that entire time.
So the current applicant, when did he take place of the station? Do you know what year?
I don't have that information. I'm sorry. I mean, I could look through and see who
it's
signed it,
okay.
but before
It's
that, it was
okay.
signed by Red Cap.
Even if it's 2015. But the question I have, never once on that form, the registry form, that was registered with the town as a convenience store, correct?
Correct.
Up to 2024, when he filled that form, that's when he put the convenience store.
So that's when they wrote on the paper that there was a convenience store. So, Mr. Latif, I think one of the issues that's important is that if there has been creep over time as far as what has been sold there for retail items, that's not unlike a situation that you as a zoning board with deal in a much easier context, right? People do stuff without permits all the time.
Right.
You know, like they build the 6-foot fence, they build the, pool too close to the, with violating their setbacks. It doesn't mean that that's allowed. It's just the town enforcement didn't deal with it or didn't know
But
about it. That sort of thing.
I want to confirm, up to 2023, the town, we never had a record. Even before 1971, it was just a gas station. Back then, we never had a record of convenience store. And we only had affidavits, which I would have even wrote one of those affidavits to say he sold soda or he sold whatever he sold in it. But again, we have no record that for the town that this was on paper, that this was a convenient gas station. And per the code, an R1, we do not allow retail in the town. And if there was soda machines, if there was cigarettes, somebody was putting the soda machine in there and they come and collect the money and so on. So that's not really, the town does not get involved with that part because it was not registered as a retail store.
So here's what I can tell you about the town's records. So in light of this application, there was a pretty exhaustive search of what the town's records are. And admittedly, some of them are more than 50 years old. So they're on microfiche, Ms. Robertson's department worked hard to make sure that we knew what the records were. And if there were records which had indicated that this was a convenience store, that would have been totally germane to this discussion.
Okay, Mr. Hess, last question. I know the town recommended a use variance. And if you can explain to us why the town went that route and what makes it better to go that way for the applicant.
Yeah, so let's just talk about this. So this application is, so first of all, let's be clear. The applicant totally has the right to ask for this hearing, right? That's your job, is to determine the code when there's an issue. So we're not questioning that part at all. But the incentive for the applicant to get a favorable decision from this board is enormous, because if the town zoning officer's decision is upheld, then this property with the current plan will need both an area variance for its expansion and a use variance for the sale of convenience items. And as Mr. Palumbo correctly pointed out, the requirements for the use variance are hard. I mean, you guys know that.
But as you mentioned earlier, what triggered this whole thing, the 600 square feet convenience store addition, correct?
Yeah, correct. Yes.
All right, thank you.
Mr. Hess, just to kind of button this up from my understanding, the town's position is the applicant has the burden to establish through competent evidence that a principal use of a convenience store existed, retail sales existed prior to 1971. That's the town's position, correct?
Correct.
All right. And that's the only way, from the town's perspective, that the appellant should prevail in this situation.
Correct. So it's the town's position that the other part of the brief or the submission from the applicant that deals with accessory uses doesn't really work for them. And that the whole issue, in my mind, is whether or not they had established the convenience store as a pre-existing non-conforming use in 1971.
And it's not the town's burden to come forward with records disproving the activities at the location prior to 1971. It's the applicant's obligation.
Right, but in respect to the applicant, they've offered some evidence, right? I mean, they offered affidavits. I don't think that the affidavits are compelling, but we can't do nothing. But my point is, if you balance the value of the town's records, which were created contemporaneously, and the affidavits, our proof is better.
Thank you, Mr. Hess. Are there any other questions?
Yes, Mr. Hess, just to also clarify what the board is being asked to do. You did mention Article 220-57, where the town board can determine special uses. Please explain one more time what steps would need to be taken either by the board or the applicant to result in that type of activity on the town's behalf.
So I'm not sure I understand the question. So is the question, what would this board need to do vis-a-vis a special use permit for this property?
Yes.
Okay, so that's an important question. So, for instance, the gasoline service station in the town of Niskayuna, you can only get one with a special use permit. So unless it's a pre-existing use, every single one has a special use permit. The problem that the applicant runs into is that neither the gasoline service station, which could be in some zones granted with a special use permit, or retail, which is allowed as of right in a bunch of districts, but not residential. So this applicant cannot get a special use permit for this use. It's just not one of the choices.
With respect to that,
Yeah.
one of the arguments that the appellant presents is People v. Miller, where it expressly says that in that decision, a prior non-conforming use is, it says, prior non-conforming use is a use of the property that existed before the enactment of a local zoning restriction. New York law has long made it clear that a prior non-conforming use in existence, when a zoning ordinance is adopted, generally is constitutionally protected, even though the ordinance may explicitly ban the activity that is subject of the prior non-conforming use.
Yeah, I agree with that.
Okay.
But the issue is that the only non-conforming use that was established was the gasoline station, not the convenience store. So if the convenience store was in existence, then there would be a different question: is to what extent would expansion be okay? Our point is it didn't exist.
So, okay. So the town holds that if the appellant has met their burden of showing that this was a pre-existing use, then that would be sufficient.
So if they met their burden of showing that it was a pre-existing use, I think it would actually lead to another question, which is what's the extent of the use? Because we have all of these decisions within the town of Niskayuna where the board has looked at, if you're approved for one thing, what can you add on? And the town has traditionally held a very tight line on that and not allowed non-conforming uses significant expansion. And you can see that in the area of how we deal with the 10% rule, right? Like, so that's so for better or for worse, New York State public policy on pre-existing non-conforming uses is we acknowledge that they should be allowed to exist, but in this case, the rest of the zone is R1. So if it went out of business, like the gas station did that was directly across Onondaga from this, which is now Berkshire Hathaway, zoning loves that, right? That means that it gets back to being more in conformance. In that case, it turned into be a different non-conforming use. But, and so listen, this is not me espousing on, legal theory, nor is it the town's position or Ms. Robertson's position. But in general, non-conforming uses, the thought is that they will go away over time.
But that's not necessarily germane to.
Totally
tonight's
not
conversation.
germane, correct.
Because
But
the applicant's taking the position, the appellant's taking the position that the prior non-conforming uses continuously existed at the location.
correct. Yes. And so listen, the broader discussion about non-conforming uses and whether what should happen to them in the future is totally not an issue tonight. Like, your job is not to, if you think that, like, it's not your job to take on that part of the role, right? Like, I don't want to send that impression at all. Your job is just to interpret the proof and in our ordinance.
Thank you, Mr. Hess.
I've got one more question for Mr.
Yeah.
This strikes me as a situation that has come up in other jurisdictions. I know we have the Exxon case.
Yes.
And I understand why that's so precedential because it's a Court of Appeals decision. Are there other cases, either in third department or others? Have we done legal research where we've got a situation where it's slightly unclear as to whether or not an accessory use is allowed in the district, and how do the courts generally find?
Yeah, so I was not able to locate any other cases that were more on point than Exxon.
Okay.
The applicant also cited another case, or at least one or two other cases, which I would say are factually distinct from what we're facing here. So I guess, Mr. Chairmarkey, my point is, if I knew of case law that was directly against our position, I would do the right thing and disclose it. Like, that would be part of tonight's discussion.
Okay. But a search for that case law has been done.
Correct.
Okay.
Thank you, Mr. Hess. Mr. Palumbo, you'd like an opportunity for rebuttal?
So let's go back to where we started a long time ago. And that's the question about the proof. And I admire the opportunity or attempt to come up with additional proof or proof of the position in the town's papers. But Mr. Hess didn't address the main issue. And that is the question that was asked by Mr. Dolman. Was it germane to talk about convenience items when you're talking about a canopy? Is it germane when you're talking about a sign? Is it germane when you're talking about an outdoor expansion of the facility to talk about what's inside the facility? No, they didn't even address that because it's not germane. For them to come in today and say that we've established it only as a gasoline station, it's just not accurate. No one asked us at any point in time, are you selling convenience items? they didn't ask it because it wasn't relevant. Those examples that they cited, every single one of them is not relevant. The only relevant one, in my opinion, is the registration issue. And the registration issue, I believe our answer is accurate. Why would this gentleman talk about adding convenience to that when it's never been added before? And when he assumes, like everybody else does, like I do, like he does, like they do, that you sell convenience items in a gasoline station. They go hand in hand. That's why that question was answered. And why was it in 2004? Well, because then that's when the issue came up. Are you selling convenience items? So he made sure in 2004 that he added it. But that's the reason why. So it goes back to the affidavits, which they have now dismissed out of hand and apparently calling our people liars because we somehow coerced them into signing these. Now, he says we didn't coerce them, but he also implicated that we did coerce them. People signed affidavits. They could have changed it any way they wanted to, but they didn't need to because it was a simple affidavit that says the sale took place of convenience items, including potato chips and all the other things that they listed in those affidavits. That's the evidence in front of this board. That's the evidence in front of the board. In 1971, you have people that came in by affidavit and said those items were being sold. They also dismissed everything after 1971, but you can't do that either because there's a question of abandonment. If they weren't sold for a period of time, then the use is determined to be abandoned. So all of those affidavits after 1971 speak to that issue, that it was a continuous sale. So you have it prior to 1971 and you have it subsequent to 1971. That's the information that this board has in front of you. And I just really don't see how you can deny it. Thank you.
Thank you. Are there any further questions for Mr. Plummer?
Yeah, Mr. Chairman, I got a question. I'm gonna go back to the registry with the town that your applicant, what year did he buy that gas station? So
Page
Can I answer-
167 shows the affidavit first signed by Harry in 2016.
Before that, Red Cap used to fill it out. I never even received that from them to do that. The station that Mr. Hess brought out, one station, that is across from Stewart's, and Stewart's owned that station, so I don't think Stewart's can compete with it itself right across the street from each other. So that's why that station is still remaining a repair shop. Okay, and this unit tire for that reason, because it is owned by Stewart's. And I don't think Harry Service Center is going to put another Harvey Service Center across the street on the other side of Route 7 to compete with them.
thank you. Back to the question. Since 2016 to 2023, did your applicant put convenient store in his application to the town in the registry?
No.
Why did he all of a sudden in 2024, he decides to put in the registry that he has a convenience store since it's been there before 1971?
Well, to go back and
I mean, why
the
all
question.
of a sudden 2024, he puts it in there where it never existed before?
Right. I tried to address that already, but let me try again. The first part of the question, I think, is what happened between 2016 and 2024? And the answer to that question is what I indicated. He didn't think about putting convenience on. It was never on before. He just continued to do what was done before. In 2024, he put it on because we are now in the middle of this discussion of whether it's a use variance, whether it's an area variance, whether it's a non-conforming use. So he added it.
I see. You answered my question because he applied, so he decided to put
Correct.
it in the registry. Okay,
Yes,
thank you. Thank
you're
you.
welcome.
Mr. Chairman, I just have one follow-up here. So when I asked town council if they believe that any of these affidavits were coerced or misleading, he answered absolutely not. He did not believe that they were coerced or misleading. However, he did think that they were not sufficient. They were too vague and not sufficiently compelling evidence. How would you respond to that argument?
Well, first of all, he said it was like leading the witness. Those were his words. So that's an
He
implication.
did, and that's
That's
why
an
I asked him
implication.
to follow up on that.
That's an implication that somebody did something wrong. When you say something like that they were leading the witness, in other words, we wrote it, told them to sign it. Well, that's not what happened. We prepared the form. They could have changed it any way they wanted to change it. He has to say something like that because he's got to get rid of those affidavits somehow, because those are the critical part of this whole equation. So he's got to say something. So he decided to say that we led the witness.
Well, when I asked him to clarify, what he said was that they were not compelling or too vague. Would you like to address that argument?
Sure. Let me have my tape. During my time living at the above location, I have frequently patronized the gas station at 2339 Troy Schenectady Road, referred to as Harry's Service Center. The establishment operated as a gas station, a small convenience store, and an automotive repair shop. That is the answer to your question.
100%. You don't have to read the whole thing. We've all got 53 copies of it or whatever, and it's in the record.
Right. That's the answer to the question. They confirmed that the sale of coffee, potato chips, candy, cigarettes, soda were all there. That's the evidence.
Okay.
They can't get rid of that evidence.
Okay.
You got to talk into the
Yeah,
mic.
that's okay.
He can talk to his lawyer.
Yeah, I mean, Harry is saying everything is licensed by the state that he is selling there, including the lottery tickets and whatever, and the cigarettes.
I did have another question do you believe, so it appears to me that the county has recognized the convenience sale de facto here, as they've accepted sales tax for convenience and tobacco tax for convenience, and in fact have come in to inspect to make sure that they're applying with the relevant laws for tobacco sales. My understanding is that the state and county are pretty strict when it comes to selling tobacco sales where you're selling tobacco where you are or are not supposed to. Is that germane to what's in front of us today?
I believe that's absolutely germane to what's in front of you today. It's just further evidence that others have acknowledged the sale that had been taking place.
Mr. Palumbo, as part of the application for those licenses, does the applicant have to state whether or not that's an allowed use in the zoning district as part of that application?
I don't believe so. The application for the license, do you have to indicate the non-conforming? No. No. I'm finished. Thank you.
Thank you, Mr. Palumbo.
Thank you.
I appreciate that.
Mr. Chairman, I have another question for Mr. Leader. Is that allowable?
I don't see why not. Mr. Leader, you want to come back forward? You're still sworn.
Absolutely.
All right.
So appreciate your time again here, sir.
Not a problem.
I wanted to bring you up because I think you're uniquely suited to answer a couple of these questions. So in the affidavit we're talking about, the affidavit says, and what the people who have signed it have said, is that the sales included, but we're not limited to coffee, potato chips, and candy, in addition to cigarettes and soda. While you were working there, you said you worked there between, was it 63 and 64?
Mid 60s, 63,
Okay.
64, 65.
Okay. At that time, were they selling coffee?
Best of my knowledge, no.
Okay.
The only thing I remember, a soda machine and a cigarette machine.
Okay. So no potato chips and
Not that I can recall.
so you moved to Clifton Park for a period of time. What period of time was that?
71 to 81.
Okay. And then you moved back to Niskuna, right?
And then back in Niskuna from 81 to present.
Do you recall in your experience a time when the convenience store expanded to start selling candy, coffee, potato chips?
I do not.
Okay, thank you.
Thank you. I think that closes the presentation portion of tonight's meeting. With respect to proceeding further, the board does have 62 days in which to render a decision on this application. This is a fairly unique type of application from the perspective of this board. We don't get a lot of these types of applications. I think that it would be useful to allow the board an opportunity to contemplate all of the testimony tonight as well as the evidence. And I appreciate the information from both the appellant and the town relative to the appeal. So I would move this evening that we table the issue. I don't know if that's the proper procedure, Ms. Finian.
The hearing can just be closed and you do have up to 62 days to render a decision. So I guess you could just make a motion that the decision not be made this evening, as with, the case of a area variance per se, and allow this board up to 60 days to render a written decision.
So I guess the question would be, at what point are we going to have discussion on the application and take a vote on this application?
Procedurally, you have 62 days, so it would be my recommendation to maybe put it on for discussion at the next board meeting with a possible vote at that time. And then you would have an additional approximate month to do a formal written decision if that's what you chose to do.
Okay, so I would move then that this evening we close the hearing and put the matter on for discussion at our next scheduled meeting to have an opportunity to discuss the matter and vote on it at that time, which would give all the members of the board an opportunity to contemplate all of the testimony and evidence that was put forward this evening. So.
You'll have to speak up. I don't know.
So my only question is, we have an alternate up there tonight. So, I mean, can you make the next meeting? Was my question. Because we wouldn't be able to have discussion on, we would be down a member, right, if he couldn't make the next meeting. July 16th.
Can I participate remotely? Yeah, I'm going to be out of town, but I can remote in.
That works.
Okay. With that information, a motion's been made to close the meeting for this evening. Is there a second to that motion?
Second to that.
All right, a motion's been made and seconded. Ms. Shakedi, will you call the roll, please?
I think you could just do an all in favor. on
All in favor?
Aye.
Aye.
Okay, thank you everyone for coming out this evening. I appreciate your time and attention. I understand that the community's very interested in this matter, so I appreciate your time. July 16th. Elena. Oh, thank you. Elena, Vin's not